Everyone, please join me in welcoming Professor David Schneiderman.
Thanks so much. It's a real honor actually to be here. It's a distinguished list of speakers spoken on Monday nights to this group, so I'm honored to be included among them. I decided to change the title of my talk today to this quote, "Dangers not fit to be communicated to the people." And this is a quote from a submission made by the Solicitor General on behalf of the King, Charles I, in the 1630s, in a famous case when the King was attempting to tax without Parliament's authority. And there are such things in regard to foreign affairs, national security, war, peace, such matters that are dangers not fit to be communicated to the people. And it's that kind of attitude, I think, that best represents what we're seeing issuing out of the government in Ottawa these days. So I want to talk to you about the events that precipitated prorogation in December 2009. And I'm thinking, of course, about access to documents concerning Afghan detainees facing torture. And what I want to talk to you about are the legal arguments. I'm a constitutional lawyer, so I'm going to tell you what I think the legal positions of the various parties to this play are about. Happily, I have in hand and are available to you as well a number of legal opinions that were solicited in advance of the motion in the House of Commons calling on the government to produce unredacted documents concerning the Afghan detainees. So I want to talk to you about the arguments that are being raised, the kind of moves, in particular, that the government of Canada is making. And I want to suggest to you that all the arguments boil down to a disagreement about whether democracy rules in contemporary Canada. So the lessons of history are pretty clear. Johnny MacDonald prorogued Parliament in order to put a halt to House of Commons proceedings in regard to an investigation of the Canadian Pacific Railway scandal in 1873. And the Governor General of the time, Lord Dufferin, expressed in his diaries, I believe, some concern about using the power to prorogue for these purposes, but nevertheless did so. Stephen Harper in 2000, I'll go down in the history books as yet another Prime Minister who used the power of prorogation to shut down House of Commons committee work. And we know that the Prime Minister was being disingenuous when he said that he needed time to recalibrate and that this prorogation was routine. We know that because the speech from the throne in March 2010 had been rehearsed numerous times before, and that the budget introduced several days later was pretty much a warmed over budget that we had seen introduced several times before. So there was simply nothing new that the government needed to do during the period of prorogation. What is clear is that the government was reacting to and anticipating the repercussions of a December 10th, 2009 House of Commons motion calling on the government to produce unredacted documents in regard to the testimony of Foreign Affairs official Richard Colvin, in regard to proceedings launched by Amnesty International regarding Afghan detainee abuse, and also related documentation post-2009. I'm just going to get my water. Sorry. Post-2005. So although the prorogation, both in 1873 and 2009, were strictly speaking constitutional, they were both unseemly and abusive of the power to prorogue. So let me turn to some of the legal arguments that were being made in the run-up to the December 10th, 2009 motion calling on the government to produce those unredacted, unblacked out Afghan detainee documents. And I assume you haven't heard much about this because there really hasn't been much in the press about these arguments. So, in the lead up to the opposition motion, the government of Canada had been repeatedly saying that it was obliged under statute not to produce these documents because they threatened national security interests. We've heard this, of course, many times before and since. So the statutes obligated parliamentarians, members of parliament, not to produce those documents. It would be contrary to law. And so what the government ministers and the Prime Minister repeated in parliamentary debates and outside of Parliament was that the government would only produce, quote, legally available documents. And legal available documents were only those that the statutes authorized the government to produce. And indeed, there are a variety of statutes that require the government to maintain secret certain documents that, for instance, cabinet documents, documents that might threaten foreign relations or national security in the course of typically legal proceedings, typically court cases, right? These are the kinds of circumstances in which documents such as these might be demanded by one of the parties to a court case, and a court can, for instance, under Canada's Evidence Act, a judge might refuse, right, the disclosure of these documents on these grounds. So this is the argument that the government was using in order to deny the production of these documents. So unredacted documents, right, ones that were clean and legible, were not legally available ones, right? Those are the ones that couldn't be produced because of a statute law. Now, the law clerk and parliamentary counsel to the House of Commons, Rob Walsh, who's a bit of a hero in this story, who's advising, he's the legal clerk to the House of Commons, so advising any member of Parliament about the law of Parliament, issues a series of memos in which he's advising parliamentarians about the obligation of the government to produce these documents. And I'll focus on the opinion that he produces on December the 7th, 2009. This is 3 days before the opposition motion. He concludes that the government has, quote, no credible basis for reaching the conclusion that that statutes prevented the government from producing those documents. The House of Commons was not the type of, quote, proceeding that these statutes were intended to apply to. All right? They typically were going to apply to courts, administrative proceedings, and the like. It was not intended that they would apply to the proceedings of the House of Commons Subcommittee on Afghan Detainee Abuse. In any event, Walsh writes, the House of Commons is, has sole jurisdiction to determine what statutes apply to its own internal affairs. Okay, so the House is its own judge about what statutes apply to its own affairs. And this is part of the law of parliamentary privilege. The House determines essentially what laws apply to it. The House of Commons is a zone in which all kinds of unlawful things might occur, right? You can be defamed in the House, for instance. You can be called a liar, which might give you cause to sue, but you have no right to sue parliamentarians for things they say in the House.